Welcome, everybody. Welcome to today's episode of The Law of Self-Defense. Almost on time, 1 minute late. Sorry about that. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you very much. So today's show, we're looking at a new law that just became effective in Texas to provide civil immunity for churches and church security volunteers, personnel, in the event that they're involved in a use of force event within the church. It's a very short bill that was passed, but interesting nevertheless. A somewhat different approach than we normally see in self-defense immunity, and a little different approach than we normally see in highly defensible property, which churches are not normally highly defensible property, although some states have made an effort to include churches within the scope of highly defensible property. We're all going to discuss all of those various dynamics in today's show. I do expect today's show to be a bit shorter than than yesterday's two and a quarter hour marathon. I did actually have a member complain that yesterday's show was too long. I guess I'm sympathetic, kind of, but when the complaint is that we're delivering too much expertise and content to the membership, it's hard to consider that much of a vice, I suppose. So with that out of the way, make yourselves comfortable, everyone. Let's make sure I'm streaming where I need to be streaming. Let's see. And it looks like everything is good. All right. So let's go ahead and launch the formal start. Well, I thought I was ready to launch the formal start of today's show. And the wrong thing spooled up. So one more second, folks, and we'll jump right into the meat of today's show. Tick tock, tick tock, tick tock. Come on, internet, here we go. All right. Welcome back, everybody. Welcome to today's episode of the Law of Self-Defense, where we're going to talk about Texas just enacted church self-defense immunity provision. Before we do, I do want to mention that today's show was sponsored by none other than American Law Courses. American Law Courses is where we provide law school level education in criminal law, evidence, property, criminal procedure, and this fall, in fact, starting next Monday, business law taught by none other than our good friend and colleague, attorney Andrew Esquire, a true world-class expert in business law. If you follow his YouTube channel, you know that's the case. Over a decade's experience and high levels of business law expertise. He's teaching our business law class. You might wonder why you would need to know business law. Well, if you're interested in amassing wealth, the best way to do it for most people is to have a business that they're running, or at least a side gig that they're running. And unfortunately, most small businesses don't have the resilience and the capital to afford to make a ton of mistakes in terms of operating the business, in terms of regulation, in terms of taxes, in terms of the laws that govern what you're allowed to do and under what circumstances. So it can be a great help in the efficiency, the success of your business enterprise, your entrepreneurial desires, to understand business law going in. And this is an opportunity to learn that at a law school level at a fraction of the time and cost of law school. And of course, without any of the woke ideology that plagues law schools today. I would urge you to learn more about this. Again, it does launch on, and these are live courses. It's semester long, 15-week program. So 15 weekly live classes on business law taught at a law school level in plain English. So I would urge you to learn more. Point your browser to AmericanLawCourses.com. We currently have this course available at half the normal registration price. Plus, we have bundles available where you can also sign up for all the other courses that we offer, the 5 or 6 or 7 other courses currently in the curriculum at American Law Courses. And of course, the more courses you sign up for, the less expensive it gets per cost. But again, you can learn all about that at AmericanLawCourses.com. All right. What else? Is there anything else I need to cover before we jump in? I don't think so. This is let's talk about Texas Bill 694, which was just became law, just became transitioned from being a bill to being a statute on September 1st, 2023. So just 4 days ago. It was passed in the Texas House, passed in the Texas Senate, and then signed by the governor on June 18th and became law effective September 1st. And it's kind of an interesting statute. So we'll look at the statutory language. It's not very long at all, but there's a couple of ways that use of force law tends to provide extra privilege to use defensive force, especially deadly defensive force, in the context of highly defensible property. And there's typical ways that use of force law tends to provide immunity from either civil suit or from criminal prosecution. And this statute in Texas is kind of a mix of both those concepts. So a little bit unusual in that context. Typically, for example, well, first of all, let's assume we all have a legal privilege of self-defense if you meet the 5 elements of self-defense, right? Up to 5 conditions of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. And by the way, folks, you can get this cheat sheet for free. We give it away for free. If you don't understand these 5 elements of self-defense, you cannot possibly understand use of force law, what's permitted, what's not permitted, under what circumstances. This cheat sheet provides a brief description of the 5 elements. You can get it for free at lawofselfdefense.com/elements. Doesn't cost a penny. It's just a PDF download. So you always have that, right? So innocence, you're not the unlawful aggressor in the confrontation. Imminence, the threat you're defending yourself against is actually occurring or immediately about to occur. Proportionality, you're not using deadly defensive force unless you're facing a deadly force threat. Avoidance, if you're in one of the few states that has a legal duty to retreat, if safely possible, you're obligated to do that before you can use deadly force in self-defense. There's only 11 of those states, but nevertheless, avoidance can be an element. It's the most commonly waived element. Obviously, 39 states don't require the element of avoidance in otherwise lawful self-defense. And then reasonableness. Did you have a genuine, good faith, subjective belief in the need to act in self-defense? And was that belief, that subjective belief, was it also objectively reasonable? Not merely speculative or imaginative based on some actual evidence from which you made a reasonable inference that you needed to defend yourself. As I say, not all 5 elements are always required. In the case of avoidance, it's the most commonly waived elements. 39 states don't generally impose a legal duty to retreat in otherwise lawful cases of self-defense. And there are circumstances in which other elements can be waived or legally presumed to have been checked off. This commonly happens in the context of highly defensible property. So your basic self-defense privilege you have anywhere, on the street, in public. You're the innocent party facing an imminent deadly force threat. Maybe there's no safe avenue of retreat if you're in a duty to retreat state, and your perception of events is both subjectively and objectively reasonable. Your use of defensive force is lawful, regardless of where you are, presuming, of course, you're someplace you have a right to be. But often the law will create additional privilege or will ease the threshold to justify your use of deadly defensive force. And it typically does this in the context of highly defensible property. So we need to think of property as falling into one of 2 buckets. There's mere personal property, items, your cell phone, for example, an unoccupied car, open, unimproved land, property. Those can generally only be defended with non-deadly force. Except in Texas. Texas does have a deadly force in defense of personal property provision. It's the only state that has that. I'm not going to dive too deeply into it, except to caution that there's lots of conditions that have to be met. And if you fail to meet a condition, you don't get the benefit of the legal privilege to use deadly force in defense of mere personal property. But if you'd like to read that statute, you can find it at lawofselfdefense.com/942. lawofselfdefense.com/942. Texas is the only state in the country that has any provision for the use of deadly defensive force in defense of mere personal property in the absence of a threat to persons. If there's a threat to persons, then it's not really a defense of property scenario, right? Then it's a self-defense, defense of persons, defense of yourself or defense of others scenario. Highly defensible property is different than personal property because it really has as a core function the shelter and protection of people inside the property. So what's always counted is your home. You're inside your home, that's highly defensible property. Often a place of business. In some states, it has to be your business is your highly defensible property. In some states, you could just be a customer in someone else's business. It's still highly defensible property. In some states, they include an occupied vehicle. If you're inside the occupied vehicle, it becomes highly defensible property. If the car is empty, if no one's in it, it's just personal property. And what states typically do, or often do, in the context of highly defensible property is if you're defending against someone who's unlawfully and forcibly intruding into that highly defensible property, a legal presumption is created that most of these elements have been checked off. Specifically, a legal presumption is created that you, the defender, had a reasonable perception of an imminent deadly force threat. Well, that's 3 of the 5 elements. That's reasonableness, imminent, and proportionality, that it was a deadly force threat. Avoidance is typically baked in the cake in highly defensible property because you don't have a legal duty to retreat in your home from an intruder. That's the castle doctrine. And innocence isn't explicitly addressed, but if you're defending yourself in your home, in your business, in your vehicle from a forcible and unlawful intruder, innocence is pretty much baked into the cake, right? You're not going to the fight. The fight's coming to you. So really, this legal presumption in the context of highly defensible property gives you everything you need to justify your use of deadly defensive force against that forcible and unlawful intruder. So it's really one of the hardest legal scenarios for a defender to screw up. They do still screw it up sometimes. They'll do something stupid, like they'll chase the intruder out of the house and down the street and shoot him there. Well, then you're no longer using force in the context of highly defensible property, right? You've left the highly defensible property. This legal presumption that's created is rebuttable by the prosecution. So it's possible, for example, say that the prosecution were to discover that you've been scheming the murder of your business partner and you invite them to your home to try to fabricate a defense in highly defensible property scenario. Well, that would be evidence that could rebut this legal presumption. There's also a number of conditions that have to be met often for this legal presumption. For example, the intrusion generally has to be both unlawful, so they're unlawfully present, and forcible. They broke something to get in. So if you're lacking the forcible, you don't get the benefit of the legal presumption. Often it doesn't apply if the person you used force against is a co-dweller, or if they're a law enforcement officer coming in the course of their duties. Now, it doesn't mean you don't have a privilege of self-defense. You still have the traditional self-defense privilege you would have out in a public street. You just, if you fail to meet the conditions or if you trigger one of the exclusions, you wouldn't get the benefit of the legal presumption in defense of highly defensible property. Now, typically, churches, places of worship, are not included as highly defensible property. And there's no particularly good reason for that. It's just a matter of public policy. They haven't gotten to it yet. Now, I am aware that some states have had bills in the legislature to add churches as a category of highly defensible property. I think Arkansas was one. I don't recall offhand whether or not those bills actually ended up being passed. Believe it or not, there are politicians who fight against this, who fight against expanding the definition of highly defensible property, just as there were politicians in Texas who voted against this church immunity law that we're going to look at closely in a moment. So one thing a state could do is take their current definition of highly defensible property, let's pretend it's already pretty broad, it's home, business, occupied vehicle, and add churches to it. And when they add churches, then when you're defending against an unlawful forcible intruder in a church, you would get the benefit of this legal presumption that you're facing a reasonably perceived imminent threat of deadly force harm. You checked off most of the elements you need to justify your use of deadly defensive force. That would be one way to go. And again, I know some states have been working towards that. I'm not sure if they've done it yet. I'd have to check. But traditionally, churches have not been included as highly defensible property. No reason for it. There's no reason not to include them. It's just a public policy question. The legislature has to make the decision that they want to include churches as highly defensible property. Nothing stopping them from doing that. Another special provision of use of force law intended to be protective of the lawful defender are self-defense immunity statutes. And the nice thing about self-defense immunity statutes is the best way to think of them is as a time-efficient, low-cost way to get a final adjudication on the question of self-defense without having to go to the risk and expense and time of a full-blown trial. So traditionally, in the absence of a self-defense immunity provision, you would use force against someone else. You would claim self-defense. The prosecution doesn't believe you. He drags you to trial on let's pretend it's a murder charge. And you have to convince the jury that it was self-defense effectively. I mean, technically, the burden's on the state to disprove your claim of self beyond a reasonable doubt. But this all happens in the course of a trial. And in a killing trial, most of the killing trials I consult on, the defense goes through 150, 200 grand in legal expenses before the trial even starts. So these things are horrifically expensive. They can often take a year or two from the time of the use of force event until you get a verdict from a jury. And that whole time, of course, your life is suspended, right? What are you doing when you're waiting to discover if you're going to spend the rest of your life in prison? Are you getting married? Are you starting a business? Are you going to college to get a degree? Are you having a child? You're not doing any of those things, right? Your life is frozen until you learn a year or two down the road whether or not you're going to be spending the rest of your life in a cage. And of course, there's tremendous risk because even the most innocent defender, if put in front of a jury, there's noise in the system, folks. The system's imperfect. It involves humans. Humans are imperfect. There's always a chance you get convicted, even if you're the most innocent defendant I've ever worked with. So trials are time-consuming, very expensive, high risk, right? If instead you can get to that same finding, conclusion, the final adjudication on the question of self-defense, was this self-defense and therefore zero legal liability or not? If you could do that in a low-cost, quick, low-risk way, that would be great. And that's what self-defense immunity hearings do for you. So you can say you're charged with murder in this hypothetical use of force event. If you're in a state that allows for self-defense immunity in the criminal context, you can ask the criminal court before the trial starts for a pre-trial hearing on the question of self-defense immunity. The judge acts as the finder of fact because there's no jury, of course, until you have an actual trial. So the judge is acting, it's almost like a mini bench trial, and you'll present evidence of self-defense and the prosecution will argue against self-defense. And different states have different legal thresholds for how much evidence is required and who has the burden of proof in these hearings. But the point is, if you can meet those legal standards to the satisfaction of the judge, he can grant you immunity from prosecution, meaning there is no trial. So these pre-trial self-defense immunity hearings aren't free. They may still cost thousands of dollars and they may still take a few days, but they don't cost hundreds of thousands of dollars and they don't take weeks. And they're low risk in the sense of if you lose at trial on self-defense, you're convicted. You go to prison for the rest of your life. No possibility of early release on a murder conviction, for example. If you lose on the pre-trial self-defense immunity hearing, well, all that happens is you get to go to trial and have a second bite at the apple. You're not convicted from the hearing. So in that sense, it's low cost. Now, there is a risk, tactical risk in the self-defense immunity hearing, and that is that you are presenting your argument of self-defense in front of the prosecution before the trial. And that may expose weaknesses in the prosecution's case that now they're aware of that they need to patch up. It may expose vulnerabilities in your own narrative of self-defense that maybe the prosecution hadn't seen before, but now they do. Maybe some of your witnesses are weak, for example. Maybe the video evidence you have is not that good. So you're putting your cards on the table for the prosecution before the actual trial and giving the prosecution a chance to buttress their own case against you. So there's a lot of criminal defense attorneys that don't like to take advantage of the self-defense immunity option for that reason. But nevertheless, it is your option. It's the option of the defense if they want to pursue a pretrial self-defense immunity hearing. And states vary on whether that hearing can provide criminal immunity, which means you can't be prosecuted if you get criminal immunity. and or civil immunity, which means you can't be sued if you get civil immunity. And normally that means two different hearings, one for criminal, one for civil, because in the criminal case, the party against you is the state. And in the civil case, the party against you is whatever, the surviving family of the person you shot in self-defense, right? It's a wrongful death suit. So there, the family is not represented in the criminal pretrial hearing. And of course, the state's not represented in the civil pretrial hearing. So you really need to do both often. Now, the nice thing about the civil immunity statutes is often they have a provision in there. Florida does, for example, where if you are civilly sued and you argue self-defense immunity and you win at the pre-trial hearing before the civil case goes to trial, then the other party is obligated to pay your legal fees. So that has a chilling effect on, gratuitous civil suits by the surviving family in an effort to pressure you into a settlement, because they know if they lose. I mean, this is why George Zimmerman wasn't sued by Benjamin Crump, for example, because he knows if he loses, he's going to have to pay Zimmerman's legal fees, and the evidence in favor of Zimmerman was overwhelming. So we have these highly defensible property, special provisions, legal presumptions of a reasonable perception of imminent death or grave bodily injury. On the one hand, that's one way to give a defender more privilege to use deadly force in self-defense. Another approach is to have these pretrial immunity hearings where you can get criminal immunity and civil immunity, both or either, depending on the state. Some states only have criminal, some states only have civil. So with that background, let's take a look at what Texas did. So first, just a note here. I've pulled up some of the legislative record. So it was signed in the Senate on May 25th. It was signed in the House on May 26th. It was signed by the governor on June 18th, and it became effective on September 1st. So just some data there on this. The actual bill itself, how does it read? So it's kind of a weird amalgamation of the self-defense immunity provisions that I just described, where you can get criminal immunity, where you can get civil immunity. They're not location specific. So it's not a case of you get immunity if you're in your home or in your business or in your car or in a church. The only question is, does your use of force meet the conditions for self-defense, meet the definition of self-defense under that state's laws? And if it does, you qualify for criminal or civil immunity, regardless of where you are. Does that make sense? Now, the legal presumptions in the context of highly defensible property are location specific. They depend on that state's definition of highly defensible property. Is it your home? Is it a place of business? Is it an occupied vehicle? Or perhaps, is it a church? So what Texas has done here is they've provided a provision for civil immunity for churches. So it's a kind of civil immunity that's location specific just for churches, and it applies to church security personnel as well. But of course, that's in the context of the physical location of the church. And this new bill is part of a bigger chapter of Texas law. Let me blow this up so it's a little easier to read. Chapter 84, Civil Practice and Remedies Code. And that code, that chapter, has a lot of statutes that are intended to protect churches and charitable organizations from civil suits. So whereas if you might be a private business, you'd be subject to civil suit if you violated a legal duty to someone, caused an injury, for example, a slip and fall kind of thing. And what the Texas legislature has said in this chapter is, listen, that's true for most businesses, right? Private businesses, we're going to hold them accountable. If they breach, well, we're going to allow a plaintiff to hold them accountable if someone is wrongfully injured by that business. But because of the value that churches and charitable organizations provide to the public, we're going to give them extra protection from civil suits. And that's just a public policy question, right? The legislature gets to decide that. They get to decide who qualifies for the special protection, and they get to decide under what circumstances, right? Now, of course, when you do this, what you're also doing is you're denying plaintiffs their day in court. So if you're saying if you were in your local gas station and you slipped in a puddle of water and broke your hip, you'd be able to sue the gas station for that. And then you're saying, but we're not going to let you sue if the same thing happens in a church. That benefits the church, but it takes away a day in court for that plaintiff who slipped and fell in church, right? Again, not making a moral judgment here. That's just a public policy question that the legislature has to answer. So what the legislature's done here is one of the existing provisions for this relief from civil suit for churches and charitable organizations was traditionally, explicitly, it did not cover intentional acts. So if you intentionally injured someone, you did not have this protection as a church or charitable organization from civil suit. If you hurt someone intentionally, you were subject to civil suit, just like a private business would be. That was a carve out. What this immunity statute is doing is it's saying, listen, despite that provision that says these protections don't apply in the context of an intentional act, we're now saying we're changing the law to say these protections do apply if that intentional act was an act of self-defense within the church, within the charitable organization, by security personnel within that institution. So let's take a look at the actual language of this new statute. The new stuff here is, for those who don't know, when legislation is changed, they'll just add words to existing law. So the existing law would be represented just as regular type here. New statutory language that's proposed is the underlined stuff. And if words are being taken out, it's a strikeout. It's a line through the words. So all the stuff that's underlined here is the new law that was proposed and became effective September 1st. So section 840067, liability arising from provision of security service to religious organizations. And they have a definition of religious organization. That's fine. Security personnel means an individual whom a religious organization hires, so an employee, to provide security services to the organization, employee or contractor, it says explicitly as an employee, or someone who is a volunteer of a religious organization whose duties or function include providing security service to the organization. So absent something like this, if you're a volunteer security person for your church, you're armed in church, right? With the church's permission. They want you there armed. You're part of their security team. And you actually shoot someone, you're subject to civil suit from that person you shot. And then you'd have to justify your act in civil court as self-defense. Let's see, paragraph B here. A religious organization or security personnel of a religious organization is immune from civil liability for any act or omission by the security personnel resulting in death, damage, or injury if the security personnel was acting in the course and scope of the security personnel's employment or volunteer duties or functions as applicable to provide security services to the organization, including an intentional act. So this takes care of that carve out that used to exist. Well, that still exists, but they're carving it out here. So now this covers intentional acts and an act involving possession or use of a firearm. Now, what's interesting about this language to me is it doesn't actually say it has to be lawful self-defense. The way self-defense immunity normally works is the immunity is a condition of you meeting the definition of self-defense, because that's what you're doing in a pretrial self-defense immunity hearing. You're arguing to the judge, Your Honor, my conduct qualifies as lawful self-defense, meets the required elements of self-defense, the definition of self-defense, the conditions of self-defense. Therefore, you should grant me immunity. That's not what this says. This says simply if you were acting in the course and scope of your employment or volunteer duties to provide security services to the organization, and you act intentionally to cause someone to do death, damage, or injury, and the act involved the possession or use of a firearm, you get civil immunity. There's no technical requirement here that says you have to meet these conditions of self-defense. Because you can imagine that you fail to meet a condition of self-defense. Say you use disproportional force. Say you use deadly force when the threat was only non-deadly in nature. That would fail the element of proportionality and you'd fail self-defense. But this is not requiring that, because even though you're doing that, even though you went disproportional, you're still acting in the course and scope of your security personnel's employment or volunteer duties to provide security services to the organization. Now, of course, this law does not provide criminal immunity, so you could still be prosecuted if you go disproportional, fail to limit yourself within the boundaries of lawful self-defense. But the statute says you'd be immune from civil suit even then. At least that's how I read this. And of course, the statute has this provision, takes effect September 1st, which is what happened. Nice of them to put that in explicitly. Now, for those of you who think, well, this is a good thing, providing this kind of protection to churches and church security personnel, you might be surprised to know that a lot of people in the Texas legislature thought it was not such a good thing. So if we look at the Texas Senate, well, maybe I'll do the House first. Is this the House? This is the House, the representatives. So 86 representatives voted yes. 53 voted no. Sorry. Yeah, that's correct. 53 voted no. And of the 53 people who voted no, 52 of them were Democrats. One Republican voted no. Pretty lockstep. 10 Democrats did vote yes, but 50 of the 53 people who voted against this provision in the Texas House, 52 of them were Democrat. Who's the Republican? I think he was down here at the bottom. That person was absent. I'm not counting them. Question mark. Where are you? Here. Representative John Smithy. I don't know John Smithy, but he was the only Republican who voted no. And then let's look at the Senate. 21 voted yes, 9 voted no. Of the 9 who voted no, all 9 were Democrats. Why would Democrats want to make it more risky for churches to defend themselves? How many legitimate plaintiffs' claims are there against churches where security personnel used force in defense of the church and the people inside the church? It makes one wonder. And all this, by the way, this Texas bill was brought to my attention by one of our law self-defense members during yesterday's live show. I'm sorry, I forgot to note down the name. He is a member who's there all the time. I apologize, but there's a lot of plates spinning when I do these live shows. And he did also direct me to this page, Texas Defense Force Security, Texans Protecting Texas. I don't know anything about this organization or the person who wrote this article, Jack Griffith, but it's a pretty lengthy, it looks like the history of this provision. So for those of you who are interested in more details, kind of the making of the sausage, I'll put a link to this page in the description of today's content. Lots of FAQs. So there you go. Again, I don't know who these people are. It looks like they're officially licensed. Lots of license numbers here at the bottom. Looks like a legitimate organization, but again, I don't know them personally. But I will put the link to this page in the description of today's show for our law self-defense members in the member blog. I'm not redoing the YouTube and Rumble descriptions. All right, so with that out of the way, let me take a look at the Law Self-Defense member chat. Folks, if you would like to comment or ask questions and have those comments and questions addressed by me during these live shows, you need to be doing it in the Law of Self-Defense member chat, which means you need to be a Law of Self-Defense member. The good news is Law of Self-Defense membership is dirt cheap. You can try it out for 2 weeks for just 99 cents, unlimited access to all our member benefits. our member content, the member chat. You get transcripts of every show for those of you who prefer to read rather than watch lengthy videos or listen to lengthy podcasts. Lots of benefits of being a Law Self-Defense member. 2-week trial, 99 cents. And if you stay a member, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law Self-Defense member. And those are the people whose comments and questions I look at this point in the show. You can do this right now. Point your browser, open up another tab, go to lawselfdefense.com/trial, sign up as a trial member, 99 cents, folks. And you'll get emailed directions for joining the show right now on the Law Self-Defense chat. So you can, if you have questions or comments, you can put them right there in the chat and I will address them. So let's take a look. What do we have? Let's see. Oscar says, thanks, Andrew. In the last 9 days, you've posted 3 videos about Texas to YouTube. Combined with today's in-depth look at Texas civil liability law for churches and church safety teams, you've given me a wealth of information with which to train my church's safety ministry. Well, that's very kind of you, Oscar. If we had a heavy emphasis on Texas, it's just a coincidence, folks. We don't try to weight by state the content we cover, but I'm great that it's proving helpful to you, Oscar. Let's see. Let's see. Chuck, Law Self-Defense member Chuck noted that there's a lot of untrained people out here with guns and other things. And unfortunately, that's true. There's also a lot of badly trained people. And there's a lot of people who are convinced that they don't need training, that they already know what they need to know. And they often know a lot, but often what they know is mostly wrong. That's certainly the case when it comes to the context of self-defense law. Which is unfortunate. Let's see. Oh, I should mention too, as long as we have a moment, not this Saturday, next Saturday, September 16th, I will be in Nashville. With my buddy, Nick Rakita. Nick is doing one of his periodic traveling get-togethers. This time in Nashville. I did one with him in Vegas a few months ago. This time he's in Nashville, and there'll be some kind of stage thing. I guess I'll be on stage. Nick will be on stage. Other people will be telling some jokes, having a few drinks, taking questions from the audience, and then we'll be mingling with the crowd. I think he has a time here. I think it's 4 or 5 hours, 6 to 11, 5 hours of personal time with yours truly, Nick Rakita, some other of the personalities that orbit around Nick. Vegas was a fantastic time. I'm sure Nashville will be as well. There is a modest cost to attend because Nick has to pay for a venue. So he is selling tickets. But if you're anywhere within an hour or two of Nashville, you'd like to meet up personally, just go to lawofselfdefense.com/Nick. That'll redirect you to this page here where you can purchase a ticket to join us on Saturday, September 16th. Much fun will be had by all. Let's see. Yeah, folks, all our shows, I tend to live stream the shows. It's more convenient for me. But for Law Self-Defense members, we make the playback of those shows available, the full length of every show. A lot of shows we have to cut off the YouTube stream, the Rumble stream, because we get to content that gets us demonetized from those platforms. But of course, the members get everything. They get it live, they get it in a playback version, and they get the members-only podcast, which of course is the full-length podcast of all our content. Another advantage of being a Law of Self-Defense member, which I would urge you to do. Let's see. Yeah, David says, spend the time to learn the laws now, or you'll possibly have a lifetime to learn the law from your prison cell. Folks, I get letters from people in prison all the time. Somehow or another, they managed to get a copy of my book. Maybe a family member bought it for them, or it's in the prison library. By the way, you can get this book for free. Law of Self-Defense Principles. Check it out on Amazon. 1,500 reviews, I think, 5-star rated. But don't buy it on Amazon. They will charge you $25 for the book and shipping and handling. I will give you the book for free at lawofselfdefense.com/free book. I do ask you to cover the cost of the shipping and handling, but we'll eat the cost of the book itself. lawofselfdefense.com/free book. And I get letters from people in prison all the time, invariably written on yellow legal pad paper with a pencil, physically mailed from the prison, stamp on the envelope, the whole thing. And basically the story is the same and often they're 10, 20 pages long, these things, because they want to tell me all the backstory about how they ended up in prison, many of them for the rest of their lives. But the bottom line is always the same. It's, Andrew, if only I'd known then what I know now, I wouldn't be in this prison. And that's probably true. So as David says, spend the time to learn the laws now. Let's see. Sir Brass says, a brand new member from yesterday, Sir Brass says, occupied property, I'd imagine, would be highly defensible property and mere personal property when unoccupied. Well, that's definitely true for cars, for sure. With homes, it tends to be built into the cake because generally the way these statutes, these legal presumptions of a reasonable fear of imminent deadly force harm in the context of highly defensible property, the way they're written is that you're dealing with a forcible, unlawful intruder, which means you're inside the house. So I've never seen them applied. I mean, I know some of you may live on a farm, right? So you might be half a mile away from your house that you know to be empty, but you can see your home. And in theory, I guess you could see someone forcibly, unlawfully breaking into your home. If you know there's no one in the home and you're not in the home, would a court grant you the benefit of this legal presumption in the context of highly defensible property? I don't know. It gets pretty sketchy because remember what these legal presumptions are really doing. They're not intended to allow you to use deadly force literally to protect the physical structure of the home. You're not allowed to kill to protect the shingles on the outside of your house or the doorknob on your door. What's happening is the property, this highly defensible property, is serving as a surrogate for the people sheltering inside the property. So if there's no people inside the property, it becomes a much more difficult legal argument, I would think. Let's see. West Virginia Bob says, what is a church? A very difficult legal question. Well, I'm not going to go into that, but I did note in the statute here that Texas does say a religious organization means a charitable organization that is a religious organization under section 110.011B. Now, I'm not going to go read that, but that's where you would go to find out what would qualify as a religious organization. There may be some kind of registration process, I presume, that would need to be done. So you couldn't just say, shoot somebody in your home and then say, oh, by the way, I have my own religion. That would not apply. Let's see. Sir Brass says, Andrew, in Indiana, the very fact that you were not charged in your use of self-defense creates a rebuttable presumption that you acted lawfully and fall under the protection of civil immunity. I would need to be convinced of that, Sir Brass. So if you have a law that says that, feel free to send it to me, Andrew at lawselfdefense.com. And if that's the case, I'll do a show on it because I've not run across that before. You also note that Indiana also requires paying of attorney's fees by the plaintiff if immunity is granted in a pretrial hearing and they're found not liable, or if found not liable in the trial. I see that a lot in the pretrial immunity stage. Generally, if you go to trial, you end up paying your own legal expenses. But again, I'd have to see the law on that. Let's see. ba, 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 ba. Ba, ba, ba. So people are giving each other tips on doing legal research online. I encourage you to do legal research. I would just caution that the only authoritative sources of law are statutes and case law, appellate court decisions. So if you're reading something that's not one of those, be very careful. And if you're reading statutes, remember that statutes by themselves have no effect in the real world. They're just words on paper. They don't have an effect in the real world until they're interpreted and applied by courts to real people. And really, the only authoritative application of the courts is the appellate courts that creates case law. So if you've read the statute, but you haven't read the appellate court decisions that apply those statutes, you may not know what that statute means because it doesn't necessarily mean what a plain English reading of the statute would suggest. So be careful about that. Jeffrey says, don't forget active shootings in churches are very rare. Make sure your security team is well trained in medical emergencies. Security teams are a great way to train a small group to handle those events. Yeah, so, the truth is, I mentioned earlier that it's pretty hard to screw up defense of highly defensible property generally, right? If you're in your home and there's someone unlawfully and forcibly breaching your home, that's about as clean a use of force scenario as you can imagine. And it's largely true of churches too. I would think it would be hard for a church to screw that up. If someone comes in and actually, what's the worst case scenario, right? Someone comes into the church and starts shooting people. Well, you just shoot that guy. That's the solution to that problem, the legally sound solution to that problem. It gets a little more complicated if someone's just coming in and causing a disturbance of some kind. And then you run the risk of, well, maybe one of your security personnel goes over the top, right? Uses more force than they should have for a mere disturbance. So you want to make sure those kinds of mistakes are unlikely to happen. You want to vet your security to make sure they're, level-headed people and they have some actual training on the law, on whatever techniques you're going to expect them to use, pepper spray, hands-on, firearms, all that kind of stuff. Let's see. Yeah, everyone should have trauma first aid training, folks. If whether you're a church security team or anyone, you probably won't need it for an act of violence event, but car accidents happen all the time, right? Traumatic accidents, injuries happen all the time. So I can tell you in my vehicles, we have trauma kits. We have chest seals, we have tourniquets, and we're rarely, so when I'm on my motorcycle trips, I'm often in the mountains hours from any place, and I have a trauma kit readily accessible right on my bike, right in my tank bag. But really, you should have them in your vehicle. You should have them in your home. The chances you'll need a tourniquet are probably pretty slim, but if you need a tourniquet, the only thing that's going to work is a tourniquet. And I would want a good one if it was for me or one of my family members. A high quality tourniquet, they're probably I don't know what they charge these days, $35, $50 maybe. I would not recommend buying on Amazon. Amazon has a lot of fake stuff on it. The quality is very poor, and you put a lot of tension on the tourniquet. So you want the real thing. So I would buy from an authoritative source. Gary asks, are you planning a class for those who took your one-day class? This would assist members with additional continuing education for documentation. I don't really understand the question, Gary. Our continuing education is really these shows. Especially for our members, we provide you with a transcript. It's both in the blog post for every show and it's a PDF download. So I would encourage you to download those and keep them in a folder on your computer or print them out and 3-hole punch them and make a book. That's what they're there for. Okay, Sir Brass, I'll check out. He sent me the Indiana statute he was referring to. I will make a note of that. Let me write this down real quick to make sure I don't forget. And I'll check that out, Sir Brass. And if it looks substantive, I'll do a show on that, because that is an interesting approach I've not seen before. All right. Gary also asked about our instructor course. So we do have a Law of Self-Defense instructor program. This is the equivalent of a semester-long law school class in self-defense law. So if a law school taught self-defense law as a semester-long seminar, that's what this would be. And it is, let's see, you can find it here, lawofselfdefense.com/instructor. Oh, I even have a banner. Let's see. There we go. We'll take you there. It's intended for self-defense instructors who want a law school level education in use of force law. It teaches you how to read case law, how to brief cases. Again, it's what a law school course, a semester-long course, would look like if any law school taught use of force law at this level, which unfortunately, to my knowledge, they don't. It's intended to put instructors in a position, because I've been a self-defense instructor, right? I'm still an NRA certified instructor in pistol, rifle, personal protection. And I've been a student in tons of classes, getting various concealed carry permits. So I know what happens. You teach the content in the course in your curriculum, and then the students ask these weird hypothetical questions. And often you don't know how to answer the questions. Now, of course, you can't provide legal advice to a student if you're not a lawyer. And I wouldn't even do it in a self-defense class. As a lawyer, I wouldn't provide legal answers, legal advice to a hypothetical scenario. But you should at least be able to explain to the student what the important variables would be, right? What facts would matter in determining whether the scenario was lawful self-defense or not. And this course is intended to put self-defense instructors in a position to do that, to have the knowledge and the tools to at least provide the framework for understanding what the answer to the hypothetical scenario would look like. Otherwise, those of you who are instructors, you end up saying, well, I'm not a lawyer. You'd have to ask a lawyer. And of course, for actual legal advice, they would need to go talk to a lawyer for sure. But to have a more robust understanding of the legal framework, what is the correct question, for example, what's relevant in this scenario, you ought to be able to answer that. And that's what this course is intended to do. So if you're interested in that, check it out at lawofselfdefense.com/instructor. Let's see. Another note from Sir Brass on that Indiana statute. Thank you for that. The more detail, the more helpful to me. All right, folks, I think I've gotten through all the questions. Northman Firearms Training and Service says he'll be taking that ASAP. I guess that's the instructor program. Here comes the train. The train track runs about a block from my office. That's great. All right, folks. So I think that is all I have for today. Not bad. Just under an hour. All right. I don't know yet what tomorrow's show will be. I'll pick out some topics, send out the usual email. But regardless, until tomorrow's show, I want to remind all of you that if you carry a gun so that you're hard to kill, if you carry a knife, if you carry pepper spray, if you practice martial arts, I do all of those things myself so that I am hard to kill, then you also owe it to yourself to make sure you know the law so you're hard to convict as well. That's what we do here at Law of Self-Defense. Thank you for joining us. Thank you, those of our members, for your ongoing support. You're what makes all this possible. And I hope you take advantage of our various books and courses as well. That's our mission here, to make all that accessible to you. So I certainly hope you take advantage of it. Until we meet again, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.